Hello everyone, welcome to the HR Notes September lecture series as well as the lecture for Legal Studies Units 3 and 4. My name is Sunny. I'm very excited to be delivering this lecture to you all today and hope you find it really helpful for upcoming exams. We're basically doing a flash revision of everything Legal Studies Unit 3 and Unit 4 today. So it will be a lot of content and hopefully it will help you to revise all of the content for this year. So you can see some resources that HR Notes has to offer on this slide, and you can see more on the HR Notes page as well. Let's jump right into it. Again, welcome to the lecture. We'll start off with a little bit of information about myself. My name is Sunny. I graduated in 2021 with an ATAR of 96.70. I received a study score of 47 in legal studies, and you can see the other subjects that I did as well. I'm currently studying a Bachelor of Paramedicine at Monash University, and I'm in my second year. So there is a lot of content today. So feel free to access the slides on the resources section of the page where you're watching the lecture, as we will be going through it quite quickly within these 2 hours. So feel free to have more of a read and look at the actual lecture slide as well. And as we go along, utilize the live chat Q&A to ask me questions, and I'll be answering them during the lecture as well. So we're doing intensive revision of Unit 3 and Unit 4 as well today. So the study design, we'll just start off with a little chat about it. This is what you should be consulting and using the most during this exam period. Print it out, have it on your desk while you study. Make sure that you can tick off all of the key knowledge and key skills dot points. Key skills indicate to you what kind of questions you need to be able to answer, and the knowledge dot points tell you what you need to know. So that's showing exactly what I said. So there are lots of resources that you should be using, in particular, the exam reports and past VCA exams. There is no more efficient study for legal studies besides revision and knowing all of your content back to front, and then application. So doing past exam questions, they're very different from what you do in school and challenging, especially section B, and marking yourself based on examiners' reports, reviewing the exemplar responses. This is the best way to study. So do as many practice exams and practice exam questions as you can under timed conditions. So there are examiners' reports. Again, really important if you're feeling a bit tired and not in the mood to study, what you could do is just read through the examiners' reports as well. So they include a lot of useful information. They give you mark averages and tips on how to get full marks, which can guide you in marking yourself as well. You see averages, you can place yourself in a section based on the marking guides and the comments that they give and the exemplar response as well, and see where you are and mark yourself on practice exams to, estimate your exam performance and the study score that you would get. So we can see some examples, dot pointing specific responses you could have given to a question. So even if you do poorly on a question, because VCA gives you all of these recommended answers and then the exemplar response, you can find out how to improve next time and where you need to work on your knowledge and understanding and application of content. We also see those high scoring responses from past students. This will not only help you with marking and ideas, but also how to improve your structure of questions and your vocabulary, remembering that you need to use a lot of specific terminology in legal studies as well. So we'll start off with Unit 3 straight away. We have a lot to get through, and I've attached the study design and what you need to know for your reference, making sure you can do all of these things, including things that we don't run through that are, different in every school. So your recent and recommended reforms, both for the criminal and then for the civil justice system as well. So 4 in total that you need to know and be able to answer those evaluate questions with regards to applying to the specific reforms that you've chosen. And these are the questions you could be asked. There's discuss, evaluate, and explain. A lot of it is about the principles of justice, which we'll have a look at now. Remembering fairness is all about impartial and just treatment without discrimination or favoritism. And when you're defining these, you need to make sure that you are not using the same words that are, the key word of fairness, equality, and access. So you need to use different words. Equality means that all people should be treated the same before the law and have the same opportunities or equitable opportunities as everyone else. And access means that everyone should be able to have an understanding of legal information and knowledge of how to access the justice system. So make sure you have a solid understanding, as these are the majority of your questions for Unit 3. Not the majority, but there are a lot of your questions for Unit 3 and likely to be what your 10 marker is about as well in the exam. So, looking at fairness, it's mainly to do with fair processes and a fair hearing. So, the everyone should be able to understand court procedures. There should be adequate legal representation and everything completed in a timely fashion. Ability to present a defense as an accused person and as a defendant as well in the civil justice system, with the opportunity to rebut or disprove respective counsel's case as well. So, cross-examination and opportunities to appeal, for instance. Equality is everyone being treated the same before the law. So people have equal opportunities to present their case, and people who are at a disadvantage have those disadvantages overcome for them. There should be no bias or prejudice, and we have unbiased and impartial judges. And we should not be treated at an advantage or disadvantage because of personal characteristics. So don't get fairness confused with equality. So here are some specific examples of the principles of justice. Fairness could mean that severe penalties are given for severe crimes and vice versa. So minor sanctions for minor crimes. We can present our case with strict adherence to rules of evidence and procedure that apply to all court cases. And if people are treated differently, it's due to application of the law, not because of their personal characteristics, putting them at a disadvantage. And then equality is where we're deemed equal in status and perceived as equal by the justice system. So everyone who comes before the law is treated the exact same. Laws are applied equally to everyone, and there are no exceptions or discrimination based on individuals' personal attributes. Access. People should be able to understand legal rights and pursue claims in the legal system. So that definition is worded without the word access being in there. Um, Everyone is able to access courts, education, information, assistance, and bodies and institutions regarding legal processes and advice and claim resolution if we're talking about the civil justice system. Wonderful. So we see another wonderful table summarizing some of the ways fairness, equality, and access can be achieved. Key concepts in the criminal justice system. So the burden of proof, you need to be able to define. It's the obligation of a party to prove a case in court, and it is held by the prosecution within the criminal justice system. The standard of proof is the degree or extent to which a case must be proved in court. So the strength of evidence that is required to prove the case. And this is beyond reasonable doubt in the criminal justice system. Defining this, it means that there should be no circumstantial evidence and no doubt that the accused is guilty in order for them to get a guilty verdict. Now, rights of the accused person. We've got the right to be tried without unreasonable delay, but we know this is a vague term, and what delay is reasonable or not is determined by the courts. The right to a fair hearing and the right to a trial by jury. And you can see the different pieces of legislation that protect these rights. So the right to be tried without unreasonable delay can be defined as the right to have one's charges heard in a timely manner, and delays only occurring if they are considered reasonable. This is acknowledging that delays do happen in the criminal justice system. They just should not be illogical or unreasonable or unfair for the accused person. And then we might see some accommodations being made, such as the accused person being released while they're awaiting trial if they don't pose a threat to society because there's an unreasonable delay that has occurred, or if they are found guilty later on, the time they spent in remand just awaiting trial could be removed from their sentence. So their sentence would be decreased based on for how long that unreasonable delay was occurring, and this can happen sometimes. So a fair hearing is the right to have the accused person's charge decided by a competent, independent, and impartial court after a fair and public hearing. This is supported by Section 24(1) of the Human Rights Charter and involves the main aspects that it involves is an impartial judge and jury, as well as an open public hearing so everyone can see it is fair and there is no bias or discrimination there. Now, trial by jury, it involves members of the community being impaneled and randomly selected from the electoral rolls, so voters, to listen to facts of the case and determine the verdict. This is supported by Section 80 of the Commonwealth Constitution. And in the criminal justice system, this is a jury of 12 members. In civil, we know it is 6. This is only accessible to individuals charged with an indictable offense. If it's a summary offense, they do not get a jury in the criminal justice system. Now, rights of the victim are protected by the Victims' Charter Act, and these are the right to give evidence as a vulnerable witness, the right to be informed about the proceedings, and to be informed about the likely release date of the accused. So we can see them all written here. The right to give evidence as a vulnerable witness will allow victims that fit into the category of vulnerable, such as if you are under 18, so you are a child, or individuals with a cognitive impairment or disability of some sort, to access certain provisions that will make accessing the criminal justice system and things like giving evidence and witness statements easier for them in court and more accommodating. So it helps to overcome the disadvantage that they automatically have. Some provisions they could receive could be a support person, such as for a child, um, judges or legal representation disrobing to make it less of a formal and intimidating environment, giving evidence through a screen or a short circuit TV, so then not having to face the accused person. And this is supported under the Victims' Charter. They've introduced support animals as well. They could close the court to the public to make sure that it's more private. And this basically allows vulnerable witnesses to have these arrangements, but the court could refuse this as well if they do not deem the witness to basically be vulnerable. Now, the right to be informed about proceedings means that victims and witnesses are entitled to information regarding the investigation of the offense and the prosecution of the accused, and they will have court processes explained to them so they understand how to navigate the criminal justice system. So this could involve things like the prosecution sitting down with victims and outlining to them what is happening in the case so that they plan to proceed with a plea negotiation perhaps, how are court proceedings going to go, what has the accused person been charged with, etc., etc. So this is the dot point list of examples of what they might be informed about. So it's basically any relevant information regarding the accused and their trial. This might involve the charges made against the accused, what they've been charged with, the reasons for not making any charges or discharging the accused person, so clearing them of all potential crimes, how the victim could find out the date, time, and place of any hearings or the trial if they did want to, say, show up or just no, and the outcome of a trial. So was the accused found guilty, not guilty, or acquitted? Acquitted maybe basically on the basis of not having enough evidence against them for a trial, after pretrial procedures, and details of any appeal made against the accused or by the accused. Now, this is a right that not all victims have, so you need to remember the criteria for this one, which is to be informed about the release date of the accused. Victims of crime are entitled to be informed of when the perpetrator of a crime against them or involving them is likely to be released from prison. But in order to do this, you have to qualify, or you're basically a victim of a specific crime. So these victims need to be registered onto the Victims Register, which is a register for victims of specific crimes. So it only applies to certain offenses, which are more serious in nature, where there might be a concern for safety or worries about the accused person being released from prison. It could be offenses involving serious assault, injury, domestic violence, family violence, sexual offenses as well, and they will be informed at least 14 days before the individual is released. So here are the things that they will be informed about. It's the length of the prisoner's sentence, their earliest release date if they qualify, release on parole, and whether the prisoner has also escaped, which is very unlikely, but it's just one of those things that is included. Next, we're going to cover Victoria legal aid for the criminal justice system in particular, but we know this goes into the civil justice system as well. So VLA's vision is a fair and just society where every Victorian's legal rights are upheld. It's a government-funded organization dedicated to providing legal representation and legal aid to accused persons who would otherwise might have limitations to accessing these services. So their roles could be to provide legal aid, funding for court proceedings or legal representation to individuals if they meet the income and merits test, so they make a low enough income to qualify, in the most effective, economic, and efficient manner, manage resources to make legal aid available at low or reasonable cost, and provide improved access to justice and remedies. So I've already mentioned they can give legal advice, legal representation, funding, and that's mainly to accused persons in the criminal justice system, but it extends somewhat to civil. There's just less that they offer for the civil justice system. So free legal advice, free legal information, that can some of that can just be accessed online or at a center as well. Duty lawyer services, so their Victoria Legal Aid funded lawyers to come and represent an accused person in court, and grants of legal assistance, which is that funding they might give to an accused person. Then we also have community legal centers. Their purpose is to provide also accessible, efficient, and low cost legal services and advice as well to the general public on a wide range of criminal and civil matters. So, a lot of the roles that they do is more focused around legal information and legal advice, and very less frequently will you be able to get a lawyer from them. But just like it says, community legal centers, they are within the community. It might depend on what your local CLC is where you can go and seek support, though some of them do not limit the services they provide, but others limit to certain groups. They will only provide services to certain groups of people or people who live in a certain area, for instance. So their roles are to provide legal advice, representation at low or no cost, a role in community education as to legal rights and obligations, and helping in achieving just and equal outcomes for their clients. There are two different types. There are generalist and specialist ones. Generalist ones basically depend on the geographical area where you are located, and specialist ones refer to the type of law that they can assist you with. Wonderful. Now, committal proceedings. These are pretrial procedures in the criminal justice system. They take place in the magistrate's court for everyone before a criminal matter is heard in a higher court. And this is for our, indictable, more serious offenses as well. So the purposes that you're assessed on, one is determining whether a prima facie case exists, meaning on the face of it. So is there on the surface enough evidence to potentially secure a conviction of the accused person in trial? Is there sufficient evidence for that? It helps to ensure a fair trial, making sure evidence against the defendant will be disclosed, so they will see the prosecution's evidence and they will know how strong the case is against them and how to prepare for it, which is fair. And it saves time by determining how the accused will plead to the charges, also trying to encourage the guilty plea a little bit here because they see all the evidence so they can decide themselves if they're very likely to get a verdict of guilty. Maybe then they should plead and get a sentence discount, reduced sentence. And it clarifies issues in dispute before the trial. So, plea negotiations as well, something that you need to know about, are discussions between the prosecution and accused, and that might be with their legal representation as well, with the accused legal representation, trying to work out an agreement to the charges laid, where at the end of it, the accused could be pleading guilty. The purposes of this is to save time, resources, and money, provide certainty for the accused person. So, also ensuring that they know how long exactly then they have to go to prison for example, or if they get a or they might not even have to go to prison and they get a less severe sanction, such as a community corrections order. And it prevents further harm to victims and witnesses, as they will not have to go through the stress of actually going to trial and doing everything all over again, giving statements, being cross-examined, etc., etc. The appropriateness of plea negotiations is a common type of legal studies question that you see on the exam a lot. It depends on the seriousness of the crime. If the crime is very, very serious, it might not be as appropriate for the accused to plead guilty, because the community and victims and witnesses may want justice to be served and see the entire trial, and it may not be appropriate for them to get a sentencing discount. It depends on the strength of the evidence. If there is little or questionable evidence against the accused, it would be a lot easier for them to plead guilty to secure a conviction of them, where it might be dubious if they actually go to trial whether they can be found guilty or not. It depends on if the accused is willing to cooperate and plead guilty. If they're not willing to plead guilty, that cannot be forced, and they should be willing to cooperate and disclose further information that the prosecution may be asking for. It depends on the views of the victims, though these are often not taken into account by the prosecution. Whether it is in the victim's interests to have the accused plead guilty, or they want their day in court and they want to see justice being served over trial. And there are the possible adverse consequences of a full trial, and that can you can also relate to preventing further harm to individuals. Um, Next are sentence indications. So an accused person can request a sentence indication, and this may or may not be approved by the judge. It is a statement by the court of the likely sentence that the accused would receive if they were to plead guilty before a trial. So during our committal proceedings, during our pretrial proceedings, this saves time, resources, and money, encourages a guilty plea from the accused, which has all the benefits previously discussed. And it assists the accused in weighing up their legal options. Is it worth it to plead guilty? What do I think are my chances at trial of this conviction being cleared? And what are their views on the sentence indication? Is it a good outcome for them? And is it a significant decrease from what maybe the original sentence would have been? Of course, the judge can refuse these, and they basically the sentence indication becomes invalid if the accused person does not take it. So if they don't take it, it becomes invalid. In terms of appropriateness, some things to consider: the complexity of the facts. If there is not enough facts known about the case and the details of the crime, it may not be appropriate to have a sentence indication given to the accused person, because it will not be reflective of the severity of their offense. So those 2 points kind of overlap. If the facts are really complex, we don't really know whether sentence indication is appropriate, and whether the period stated that the court will then have to adhere to later, if the accused pleads guilty, is appropriate and is sufficient for the severity of the crime committed. If there is sufficient information, and whether a sentence indication has already been given for indictable offenses, because if it's been given, it should not be given again. So the court hierarchy that you need to know of. In Victoria, the magistrates court is where our summary, more minor offences go, such as minor theft, speeding, often results in a fine as the sanction. County court, more serious indictable offences go here, such as sexual offences might go here, often results in CCOs or imprisonment as the sanction. Supreme Court Trial Division, and Court of Appeal, again, more and more serious offences go here. We see murders, manslaughter going here, for instance, and large volume drug trafficking. And the High Court is, Commonwealth's highest court, but it's also part of the state's hierarchy, because state-based claims can still go here. So you need to make sure that you are all across both the original and the appellate, so on appeal, jurisdictions of all the courts within the hierarchy, and that goes for both the criminal justice system as well as the civil justice system as well, being mindful that they are different. Now, on the court hierarchy, what are the reasons for a court hierarchy? So there are appeals. If there are grounds for an appeal, a party who's dissatisfied with a decision in a criminal case can take the matter to a higher court in the hierarchy, so where the judge will have even more expertise, to challenge the decision, and if the decision was wrong, to have it corrected. And both the prosecution and the accused person can do this, and it therefore helps to ensure fairness. But there needs to be sufficient grounds for an appeal, and it needs to be approved by the court system. There's no automatic guarantee or right to an appeal. Specialization as well. So this is the idea that judges and courts hear similar cases all the time because of what cases go to their jurisdiction. So because of that, they're able to develop expertise or also specialization in those areas, which makes sure that cases are resolved similarly and fairly. And it saves time and resources and prevents backlog in the justice system. For instance, the magistrates court specializing in committal hearings, or you can use some of the examples that I mentioned of offenses in different tiers of the court hierarchy. Wonderful. Now, responsibilities of personnel in the criminal justice system. Be mindful again, responsibilities of personnel in civil justice system differ slightly. So the judge has to manage the trial, and he makes sure they make sure that the correct court procedures are followed. Have ability to give directions for court proceedings, such as setting deadlines, limiting cross-examination time, for instance, and they can clear up ambiguities and things that are unclear made in submissions by the parties. They also decide on the admissibility of evidence, whether it can be admitted or not, making sure that evidence is compliant with the Evidence Act 2008, as well as common law, judge-made law. They also attend to jury matters and instruct the jury and tell them what to do and instruct them. And they also hand down a sentence or a sanction. This also depends on whether or not a jury is appointed or not. Because if a jury is not appointed, then they will also provide a verdict of guilty or not guilty. But for more serious indictable offenses, it is the role of the jury to decide the verdict. However, in all cases, the judge decides the sentence or appropriate sanction to be applied, whether that's a fine, CCO, or imprisonment. Now, the jury, which we know is only involved for indictable offenses, has to be objective. They have to bring an unbiased and open mind, decide the case based on the facts and the law alone, and not on any personal bias and factors. They have to listen to, take note of, and remember the evidence. They have to choose a foreperson to represent the jury and basically deliver the verdict as well, participate in deliberations to decide the verdict for the case, whether the accused is guilty or not guilty. And a unanimous verdict is required for most serious offenses, which means 12 out of 12 must agree on the same verdict of guilty or not guilty, but a majority verdict of 11 out of 12 jurors could be accepted for certain offenses. So there needs to be a high level of certainty, and if the jury fails to come to a decision, it might be a mistrial where the accused will actually have to go to another trial with another jury appointed. They're also legal practitioners, or you could also, understand that these are lawyers. They have a lot of duties to the court that they must comply with, such as acting ethically, avoiding deception, always telling the truth, being in accordance with the law, not misrepresenting the law or their client's case. So they do have to do their very best job to represent everyone as well. They must present their client's case in, therefore, the best light possible, and inform the accused person of their legal rights and all of their options involving guilty pleas as well. Now, the parties, which are the prosecution as well as the accused person, must provide an opening address to the jury judge. Of course, legal practitioners may do this on their behalf if they are appointed. They can present their case to the court in an open, diligent manner, and they have the same duties to the court, such as deception, acting ethically, avoiding deception, acting ethically, being honest and truthful, and they can make submissions about sentencing. Again, legal practitioners may do this on their behalf. So why should the accused be found or plead guilty? So the prosecution will go and talk about why the accused should be found guilty and why they should get a more severe sanction, whereas the accused person will do the opposite and present a summary of why they should not be found guilty and why their sanction should be more lenient. So they do the opposite. Remembering back to our purposes of sanctions, this is really important. There are a lot of questions on this that come up quite frequently on exams. And this is our Doctor DPP, which is just an abbreviation that I thought maybe if you like it, you could use it. if you find it difficult to remember. So here they are. Deterrence, which is whereby the sanction aims to discourage the offender and others in the community from committing similar offenses. If it's just discouraging the offender, it is specific deterrence, and if it's deterring others in the community, it is general deterrence. So, if we want to deter, the judge may make comments, give some comments trying to discourage the offender and others in the community, saying this is, a very serious crime, and they will impose a more severe sanction, such as imprisonment, for instance. Denunciation is whereby the court demonstrates the community's disapproval of the offender's actions, that they've committed a really serious crime and that it's not okay. And they might often say things like that this crime is an issue in the community as well, and therefore must be punished severely. So this will also lead to the imposition of a more serious sanction, often imprisonment. Fines or denunciation, not very effective at achieving these, really any of these. But a fine cannot really demonstrate any denunciation, and it cannot demonstrate any rehabilitation either. And deterrence and protection, all of those are not achieved to a high extent. But if you think about a protection, the offender gets a fine, and they can just go about living in the community, doing the same things that they've always done. Rehabilitation, the penalty, the sanction isn't serious enough to promote any rehabilitation or have any conditions attached to it, because it's just a monetary payment. And denunciation, we can increase the fine for denunciation and deterrence to higher in the bracket of the fine, but this will not discourage wealthy offenders. Rehabilitation aims to reform an offender to reduce recidivism or prevent reoffending. CCOs are actually community corrections orders. CCOs are actually better for this than imprisonment because they have a lot of conditions attached that may involve rehabilitation that the offender will have to comply with, whereas imprisonment is often likened to almost like a crime school, and rates of recidivism returning from prison tend to be very, very high. I think 40% within 2 years following being imprisoned tend to reoffend and end up in prison again in terms of accused persons. So protection as well, a strategy designed to safeguard or protect the community from an offender. Imprisonment is best for this because they will be held in custody by the state. Those CCOs can also limit visitation rights to certain places. So there might be place exclusion, alcohol exclusion. They won't let the offender leave the state, etc., etc. And punishment aims to penalize the offender and prevent them from reoffending. Where if we really want to punish an offender, we will give them a sanction of imprisonment, and we will also again make the sanction more severe, so a longer sentence. Um, Wonderful. And then the types of sanctions, which I've mentioned already, so hopefully help to tie everything together. A fine is an amount of money ordered to be paid by the offender to the state of Victoria, and this is in penalty units. Penalty units increase with inflation every single year. It's somewhere around just about $150 for a penalty unit, and I think closer to $200 now, increasing with inflation. Imprisonment is a sanction that involves the removal of the offender from society for a stated period of time and placing them in prison. And this is our most serious sanction that we can impose. And community corrections orders are supervised sentences served in the community with special conditions that will be modified for each offender depending on how they have offended and what is perceived as necessary by the judge and what they think is best to assign to that individual. So having a look at the sanctions, this is a beautiful summary table for you showing what best achieves which purposes of sanctions. So for example, we see with fines, there is some punishment due to financial loss. However, this may not be sufficient for wealthy offenders. We see with deterrence, we may not want to have a monetary penalty again if we reoffend, but that's again limited for wealthy offenders. Denunciation could be achieved by a large fine as well. Again, wealthy offenders come into play here, though, as a weakness. Rehabilitation and protection are not achieved at all because a fine cannot go into those areas, restrict the movement of an offender at all or lead them into any rehabilitation as well. CCOs have conditions attached that may aim to punish. Deterrence in terms of CCOs, individuals may not want to be subject to the conditions again after they've offended. Denunciation can be achieved by placing a large amount of conditions onto the offender and making that excessive and very limiting their freedom, including community work is really good for this, and rehabilitation programs designed to reform the offender. So they might have to go to rehabilitation services for drugs or alcohol if that was a reason for their offending. Again, that community work, unpaid work in the community to um, build life skills and social skills for them and things like that, and consistent reporting to CCO centers. Imprisonment, best at achieving punishment due to loss of freedom and liberty. Deterrence, people don't want to be deprived of their liberty as well, and serious prison terms might discourage members of the public, so general deterrence. We can impose a longer sentence to achieve denunciation and really condemn that offender. And programs may be offered for rehabilitation in prison. However, they are very limited and there are often long waiting times for them. Recidivism rates suggest that rehabilitation is ineffective in prison, and if we want to rehabilitate an offender, we give them a CCO, especially if it's a younger person who's offending. It achieves protection by removing the offender from society as well. So that's a good summary table for those questions that ask you to consider how effective certain sanctions are in achieving the purposes of sanctions. All right, now our factors considered in sentencing that we need to know of. These are aggravating factors, mitigating factors, guilty pleas, and victim impact statements. So aggravating factors are circumstances relating to the offense, victim, or offender that increase the offender's culpability and the severity of the crime, therefore likely to lead to a more severe sanction being imposed, such as a longer period of imprisonment. This could be the fact that they already have a previous criminal history and this is not their first offending, that the crime was planned, for instance, and had that specific intent behind it, and that it was really vile or serious. Maybe it was against a minority group or a vulnerable person, etc., etc. Now, mitigating factors relate to factors that decrease the offender's culpability and the severity of the crime, thus resulting in a more lenient sanction. So it's the opposite of aggravating factors. These could be things like the person is a young person, they have no previous criminal history, the crime was not planned, um, and yeah, those kinds of things. Guilty pleas as well are obviously going to act as mitigating factors. Even the Sentencing Act requires that a less severe sentence is imposed if a guilty plea is made by the offender. And the earlier they do this, the more the sentence will be reduced. And this is called that sentencing discount that I was referring to before. It will also consider the stage at which the plea was entered. So what I'm saying is the earlier it's done, the larger will be the sentencing discount. So the time off what would have been their original sentence. So hopefully this aims to make reduce backlog and make this even more timely so that most offenders would plead during committal proceedings. Now, victim impact statements detail the effects of an offense on the victim through words, drawings, written or verbal statements, and they can be made on behalf of a victim in certain circumstances, such as if the victim is a child, their parent may make the victim impact statement. So these can act as both aggravating and mitigating factors. Usually aggravating, though. So usually a victim will indicate that the offending had a serious and negative impact on their life, and thus this may lead the judge to consider that due to the significant impact, they should increase the severity of the sanction to be imposed on the offender. Sometimes, however, victim impact statements could be more forgiving and may act as a mitigating factor in those circumstances, but this is very rare. Wonderful. So that's the main things for the criminal justice system. And now we'll head into the civil justice system. Again, looking at the study design, all the things that you need to know, not as much here, remembering again that you do need to know reforms for the civil justice system as well. So let's compare the key concepts in the civil justice system to the criminal justice system now. So the burden of proof, again, the obligation of a party to prove a case in court, it rests with the plaintiff as they are the party bringing the civil claim to court against the defendant. They are the ones initiating the claim. The standard of proof is on the balance of probabilities, a much lower standard of proof than that in the criminal justice system, which means simply that the judge overseeing the case will have to decide which version of events and facts is more likely, the one presented by the plaintiff or the defendant, and that's based on everything they do in court and all the evidence and the points they raise. They decide which is more likely to then decide if the defendant is liable or not liable. We need to know representative proceedings as part of the civil justice system as well. They can also be referred to as class action, whatever term you're more comfortable with. This is where one person, referred to as a lead plaintiff, they represent the plaintiff group, brings a case against a defendant, which is often like a company rather than a person usually. And this is done on behalf of at least 7 or more plaintiffs in total in order to qualify as a representative proceeding. Also, the facts of all of the cases of all of these people in the plaintiff group must be similar in all of the cases that are being brought together. They have to be similar facts. This is common for small claims where a lot of people are affected. Say a company charges a bunch of its customers $50 for a service that they did not provide. These people, it would be too expensive and time consuming for them to go against the company and pursue independently these small civil claims. So instead, they might come together and have a class action where they could even qualify for funding from for the proceedings and make it free, or they only have just that one person act as the lead plaintiff and they don't even really have to be involved in the trial. They will be They will qualify for the compensation if it is proved that the defendant is liable. All of them will get the same compensation. So this is where we often see representative proceedings is those small claims, but it's against a large group of people, so they can come together, save time, money, resources, and stress, and benefit from representative proceedings in that way. And these go to the Supreme Court Trial Division, which you need to know. It's part of the jurisdiction. So what are some of the benefits of representative proceedings? Well, the group members can share the cost and they can often even get funding. So a litigation funder or company could be prepared to fund the class action. And they often ask for a percentage of the damages received if it is successful as compensation. But they also take the risk that if the class action is unsuccessful, actually the legal representation would then be free for the plaintiff group. So this is really beneficial to plaintiffs that they can even get that funding where if it's not successful anyway, they will not owe anything. It's a more efficient way of court dealing, saving court time, plaintiff's time, and reducing court backlogs. People can pursue civil action that they may not be able to afford or access on their own as well, which of course increases access. And what are some specific benefits from for the individual themselves? So they are able to pursue a case that they otherwise may have not been able to afford to pursue. And often those large corporate law firms can take on the class actions for free or minimal cost to the plaintiffs, which, like I said, it might be a percentage of the damages that they make if they're successful in proving liability of the defendant that they might have to pay to the firm for the service. And disadvantages include loss of control over their case. So if you're not the lead plaintiff, you're not very involved at all. You don't really have control over how the case goes. And if you're concerned about making sure that it's successful, it may be in your interest to pursue the claim individually, so that you know about the strength of evidence, you know what's happening, you can choose the evidence to use, etc., etc. It's also less individualized, causing individuals, members of the plaintiff group, to feel unimportant or that their voice isn't heard within the case and they're not really involved. Benefits for the court. So it's a streamlined process of representative proceeding. Multiple individual cases with the same fact scenarios are not tying up court resources because the outcome for the lead plaintiff will be the same outcome for all members of the plaintiff group, whether that's the defendant being liable or not liable as the verdict. Um, that will apply to everyone, and it saves court times and resources. Again, less focus on individuals within the courtroom, however, and there is that risk of I guess the facts not being presented in the best light for the plaintiff group, leading to an unsuccessful claim, which will affect other members of the plaintiff group if that were to happen. But it's usually not the case. Considerations you need to know for the civil justice system that the plaintiff has to make when they think about initiating a legal claim. Be able to explain all of these and apply specific examples to stimulus material that you could be given on the exam. I used an abbreviation to help me remember this in year 12, which was CLENS, so CLENS, and it really helped me a lot. I really recommend that if it would help you. So we'll go through quickly one by one each of these. It's cost, limitation of actions, enforcement issues, negotiation options, and scope of liability. You need to have a good understanding of all of these. Now, negotiation options. So this is where the plaintiff in a civil dispute might enter into informal discussions with the defendant, with or without each other's legal representation, in attempts to cooperatively resolve the dispute without it having to go to trial. Some examples of this are all of our alternative dispute resolution methods, which I'll now refer to as ADRs. Mostly mediation and conciliation are used for negotiating because they're more informal, more cheap, nice and quick. Arbitration does involve a more formal hearing, so it's not as common. And parties can directly just negotiate with each other without any third party, and just make offers to one another during any stage of proceedings. They could agree to this and settle on a payment, for instance, that is agreed to by both parties. So the benefits are that it saves cost, time, and stress. Parties have control over the outcome. There's no outcome that is forcefully imposed on them, so they can choose an outcome that is agreed to by both parties. They're more prepared to accept the outcome if they've already agreed to negotiate, means that there is some willingness to potentially come to an agreement, and they can contribute to resolving without having to go to trial and each contribute their own thoughts. But it's not appropriate if one or even both of the parties do not want to resolve because, again, they have control over the outcome. So we cannot force in mediation or conciliation one of the parties to comply. There's no imposed outcome. It depends on the parties agreeing to it, both of them. If there's been previous failed attempts to negotiate, it's not likely to be successful. If there's harm or threat to one party or a power imbalance, there might be a forced outcome that the other party might not agree with, might not be good for them, but they basically get taken advantage of and they agree to that outcome, even though it's not the best thing for them. And if there's urgency to have the matter resolved in court, or one or more of the parties really want the matter to be resolved in the court system. Um, Next, cost. This is a really easy one to answer your questions based on. And these are any related costs incurred through the civil justice system. And with these factors, we talk about the plaintiff, so the cost that the plaintiff may incur. And these are very, very significant, very high. Some examples of cost in taking a civil claim to court are lawyers. They're usually costing between 200, 600 per hour. And if you want to get your expert, famous barristers, even much more than that. Jury costs, such as within the county court, if you have a civil jury, one day, the first day costs about $800. The pleadings also very expensive, and that's for a claim of less than $100,000. So as you can see, very significant. Pretrial procedures add significantly to cost as well, especially because during that time we're, still have our hired legal representatives and we have to pay them that whole time. And even a statement of claim, so initiating an actual claim for the plaintiff costs a lot of money. And if the plaintiff is successful in proving the defendant's liability, uh, they will get money back for court proceedings if they're successful. However, this will not cover all of their legal fees. Similarly, if they're unsuccessful, they will have to pay back the defendant's estimated legal fees, unfortunately. So there is a big financial loss if things don't go well, and there is a financial loss either way to an extent. So the plaintiff really has to consider this when initiating a civil claim. Next is our limitation of actions. This is the restriction on the time limit or the time limit within which a civil action has to be commenced or initiated by a plaintiff. After that, it will basically expire and you cannot take any action against the defendant anymore, which is very, very fair because as a defendant, you should not be worried your whole life that 20 years later, the plaintiff can initiate a claim against you based on something that happened ages ago and there's no viable evidence for that claim. And it's only on the balance of probabilities, remember, in the civil justice system. So things could go very, very wrong and it would not be fair on the defendant. So initiating civil action should happen when there's still fresh evidence. It's happened relatively recently, and it's clear that the plaintiff is honest and they're seeking compensation for something that's happened to them not too long ago in the past. And it makes sense. So most of these are listed in the Limitation of Actions Act 2002. It does allow for some extensions, but there are very limited circumstances in which you can apply for an extension, such as if you were in a coma or you were so medically seriously injured that you could not initiate a claim at all and go for the court system, you might qualify for an extension because of those personal circumstances, making you completely incapable of initiating a civil action. So, some examples of limitations of actions. Defamation cases can only be commenced within 1 year of the act occurring. If you think about this, that makes a lot of sense because we definitely need viable evidence for defamation that can quickly disappear with time. Injury, negligence, 3 years for the limitations periods. But you don't actually need to know specific periods, just understanding what limitation of actions is. Sometimes, though, if you do know these most common ones, you can use it sometimes in exam questions. If you use limitation of actions, and you can say, oh, wow, this stimulus is about defamation. So if I discuss from cleanse the limitation of actions as the factor for the plaintiff to consider, I'm actually able to bring in the specific period for defamation limitation of actions just because I know it. I have that extra background knowledge. So it still can be helpful if you're looking to be a very high scoring student in legal studies and add to showcase that extra level of knowledge. Now, the scope of liability requires that the defendant was the cause of the damage and the loss or damage was not too remote from them. This is a more complex one, but one that you need to understand because if it's relevant to a stimulus that you've been given, you will have no choice but to apply it. So make sure that you're still all across it. Some of the examples of this are tests for remoteness. This involves looking if the damage was reasonably foreseeable and the defendant could have prevented it and basically not done what they did in some way to injure or harm the plaintiff. So if a reasonable person would be able to discern that if I do this, this might result in harm, that means the defendant should be held liable. However, if it absolutely doesn't make sense that the thing that I did somehow managed to affect the plaintiff and it was pure coincidence, it will not pass the test for remoteness, and me, as the defendant, I will not be held liable for that. There is the eggshell skull rule, though. You have to take the victim as you found them. If the plaintiff is significantly fragile, weak, has some kind of factors in their life that made them more susceptible to that harm when the incident happened, or maybe if the incident resulted in more harm to them than it would in a normal, more healthy person with different circumstances, the defendant is still going to be liable for all damage to the victim or plaintiff. Because if they were not, that would be discriminating against the plaintiff when there are factors outside of their control that resulted in more harm. So that upholds equality. Another thing is that plaintiffs themselves can be part of the problem and part of why the damage has occurred to them, or they may not be suing the appropriate person, and there might be other persons, individuals, or groups that were the people that should have been taken to court instead. And the scope of liability will look for those things and discern those things as well. Next, we have enforcement issues. These are the complications or difficulties that may occur during the application or execution of a court order. So let's imagine the defendant is found liable. Now we need to enforce that they pay damages, for instance, to the plaintiff. So there might be some complications involved where the plaintiff may not be able to receive their compensation. For instance, if the defendant is not able to afford the damages that the plaintiff has been awarded or is asking for, or maybe if the defendant is not in the country, so it could be difficult to enforce, or they are bankrupt, which kind of relates to the other one. If there's someone who is in prison within the criminal justice system, they may not have any funds or ability to make any funds as well to financially compensate the plaintiff. So this is a big one for plaintiffs to consider. And that's cleanse done. I will keep saying cleanse. I feel like it has a nice ring to it, so feel free to use that abbreviation if it helps you guys. Consumer Affairs Victoria now. This is for our civil justice system. They utilize as their primary and only really dispute resolution method conciliation. So they conciliate disputes between specific jurisdiction, consumers against traders and businesses, and tenants against landlords. It cannot be the other way around. So landlords against tenants, no, big no. Plaintiffs have to be consumers or tenants. And it has to be against traders or landlords. So they're mostly for consumers, right, of certain services. So whether that be buying certain products or renting. So they use conciliation, and they also educate individuals on their rights and responsibilities. This is a free service. As a trader, as a consumer or tenant, you can just initiate a claim. However, we know that conciliation is not legally binding and an outcome cannot be forced. So if you qualify for this service, it depends on your trader and landlord being agreeable enough and being willing basically to settle and come to a resolution. So conciliation is guided by an expert. In mediation, we only have a facilitator, someone just to guide the discussion. They can't suggest any solutions. But when we see conciliation, we see an expert in that area of the law, and they suggest specific solutions. However, they cannot impose an outcome. And this makes sure basically some more simple ways to word their purposes for questions. They ensure businesses comply with consumer laws. They help people to exercise consumer rights and educate about what their consumer rights are. Provide safe and fair residential tenancies, so rentals. Encourage modern, effective consumer law framework as well. So when determining whether CAV is appropriate for a plaintiff to potentially go to over the court system or other alternative dispute resolution methods, we need to consider firstly whether the dispute is within CAV's jurisdiction, because it is a very narrow, small jurisdiction and most disputes cannot go here. And also whether the dispute is likely to settle. Is it going to be likely that the defendant will be agreeable enough and willing to negotiate and try to come to a solution? If not, we should take instead the defendant, for instance, to VCAT or the courts, where there will be a binding, legally enforceable outcome. Whether the claim is from a tenant or a consumer, because it has to be in order to qualify for CAV. Whether the parties are both willing to participate in conciliation, because attendance cannot be forced, and whether there are other or better ways to resolve the dispute, say, for instance, in that circumstance where the defendant is not wanting to comply or even attend these proceedings. So it's appropriate when parties are willing to discuss the issue in conciliation and are able and willing to come to a resolution themselves, and also when they have limited money or funds because the service is free. It is inappropriate if parties refuse to discuss the issue because CAV cannot force parties to comply or show up. And also when a case does not fit under CAV jurisdiction. And these are types of questions that you can get about appropriateness as well. Now VCAT. Its purpose is to hear smaller civil cases more efficiently and effectively, and to provide cheaper services than the courts, more affordable for persons. So it reduces costs such as lawyers, certain fees, and the free tier payment system. And it even has different fees for different lists or different civil claims that take into account how complex they are. And basically, you can access VCAT for certain claims for not a whole bunch of money. So it saves time and it saves money, making it much more accessible to many more people. It's faster as the courts because there aren't as many procedures. So it's relatively formal. However, it's not as formal as the courts. They often use arbitration as the dispute resolution method, where it imposes a legally binding outcome on the parties and is a little bit similar to a court hearing, but it's overseen by an arbitrator rather than a judge. And we saw it was 10 weeks for civil claims in 2015-16. It's a little bit longer now, but not too significant compared to the courts. There's also efficiency due to the fact that they use less formal and less pricey procedures, and often people that go to VCAT, they don't even really need legal representation to navigate VCAT, and most people don't get legal representation. Appropriateness. So we need to consider whether disputes are within VCAT's jurisdiction, which most things will fall under VCAT's jurisdiction. It is very extensive. The costs and the time involved. Um, so how much can parties afford going through the courts or not? How long is it in a party's best interest to have the claim resolved as quickly as possible? Whether the parties could resolve the dispute themselves, because then they might instead access CAV or alternative dispute resolution methods. Whether they prefer the formality of the courtroom and trust in the expertise of the judge more, they might just pursue it through the courts. Whether the matter is large or complex, so then it should go to the courts to if it requires statutory interpretation, have the judges do that, or if it requires navigation of a complex legal issue, have judges do that, because we know there are limited opportunities of appeal from VCAT, and this will be very expensive and time consuming as well, may not get approved. So if it's large or complex, we should go to VCAT just at the risk of an incorrect outcome as well. If we need an appeal, um, and if there's a reason to apply new common law, it's not going to be appropriate for VCAT. And as well, the doctrine of precedent. So when it's appropriate and inappropriate, when a party wants to resolve their dispute through mediation or arbitration, it might be appropriate because VCAT often uses these methods. These are their main methods. Often trying mediation first, and if that doesn't work, they often try arbitration, where that binding outcome is imposed. When a party does not wish to go to court but wants a legally binding decision, VCAT is ideal, and this is provided by arbitration but not by mediation. When a party does not wish to have a lawyer or cannot afford to go to court because these things are not necessary in VCAT. It is inappropriate if, although costs are usually lower, it might still be very expensive, especially depending on what kind of civil claim the plaintiff is trying to pursue. Sometimes waiting times can be very long for certain lists, such as planning disputes. I think about a year. When a case does not fit under VCAT's jurisdiction as well, it obviously cannot go to VCAT. And that might be even for exceeding monetary jurisdiction. So how much money is the plaintiff trying to claim from the defendant? It's usually that it will fit into most lists because VCAT has such a big jurisdiction, but it might be exceeding their monetary jurisdiction. So how much money for the claims? So you need to be able to compare VCAT and CAV as well. VCAT is a tribunal, whereas CAV is a government government established complaints body for tenants and consumers. VCAT has jurisdiction in many disputes, including administrative, civil, human rights, and residential tenancies. So they can do the same things that CAV does, really, because we see residential tenancies on there as well. CAV has jurisdiction in the supply of goods and services, owners corporations, retirement villages, and residential tenancies. If it's easier to remember, you can remember tenants against landlords and consumers against traders. VCAT uses mediation and other methods, so they can use all of mediation, conciliation, arbitration, though they commonly use mediation and arbitration, and CAV uses conciliation commonly. That's their only type of resolution method that they can employ. VCAT has some filing fees and hearing fees for certain claims. Really, most of them, there will be some kind of monetary payment involved. However, CAV is completely free. The conciliation process is completely free. So there we go. And that you can contrast the two very nicely there as well. So the purposes of pretrial procedures are to encourage an out-of-court settlement. This is the civil justice system, of course, and mediation helps to achieve this for the most part, and as well as other, I guess, alternative dispute resolution methods outside of court. But we are talking about pretrial procedures in the court specifically, and we know judges send, usually using their power to give direction, send pretty much every dispute to mediation first just to see if it could get resolved and save time and resources that way. To provide the courts and parties with key information, pleadings often helps to achieve that, where the information is exchanged, and to speed up the dispute resolution process, which is our directions hearing, where the judge gives directions, gives a date for the trial, etc., to allow the parties as well to determine if a trial is worthwhile, which is directly done by discovery, which is the exchange of evidence between the parties and submission to the court so they can see the strength of each party's case against the other party. So the civil court hierarchy is the same courts, but remember that original and appellate jurisdictions are different, and this you will need to revise. Generally, in the magistrate's court, it's claims under $100,000. Claims that are under $10,000 get basically fast track sent to an arbitration hearing. So even though it is the courts, claims under $10,000 usually just don't get a court hearing and they go to arbitration. Everything else, claims over $100,000, remembering Supreme Court Trial Division has representative proceedings as well, and revise your appellate jurisdictions because they are different between the criminal and the civil justice system. Now, the reasons for a court hierarchy that you're assessed on here slightly differ. Instead of specialization, we see administrative convenience. This refers to the fact that the existence of the court hierarchy allows for civil cases to be distributed according to their complexity and seriousness, meaning that less serious or complex cases will be heard in the lower courts, such as those more minor claims being heard in the magistrate's court, whereas more serious, complex cases, such as representative proceedings, will be heard in the higher courts. And this allows courts to allocate their time and reduce delays, meaning that for those simpler cases, less less time and resources will be allocated and they will be quickly resolved, which is appropriate given that the lower courts, especially the magistrate's court, will have the highest volume or amount of cases being heard there. So they need to get quickly through them. Whereas higher in the hierarchy, there will be little claims going to Court of Appeal, Supreme Court Trial Division. However, these will be complex, like representative proceedings. They will require a lot of time and a lot of resources, take a very long time to be resolved. Therefore, we need a lower volume of cases to be going there. So this essentially prioritizes efficiency. That's why we see convenience, administrative convenience. It rings a bell, right? It reduces and saves time for the court system and reduce backlogs effectively. Then we also have appeals again. This is the same. Matters can be taken to higher courts where cases can be heard with judges overseeing that have more superior and specialized expertise, and outcomes can be corrected, whether that's of the plaintiff or defendant submitting an application for an appeal. Powers of case management. So all of the judicial powers of case management were given to the Victorian judges with the passing of the Civil Procedures Act 2010. This gave judges a number of powers when dealing with a civil case, including powers to refer a case to mediation and powers to give any directions they deem necessary for the case. So you need to know about the judges' powers of case management and be able to discuss them. But judges referring a civil case to mediation, we know this is always usually done during pretrial procedures for every case. And giving directions can include a bunch of things like setting deadlines, determining what evidence and how many pieces of evidence can be submitted for discovery by each party, um, limiting cross-examination time on witnesses, etc., etc. And these powers, overall, their purpose is to facilitate the just, efficient, timely, and cost-effective resolution of the issues in dispute in the civil dispute. So, directions refer to instructions that are given by the judge. They compel a party to do something, usually by a certain time, or could apply to both parties. So, you need to be able to define this. So, I already mentioned some examples. We see some on the slide. Limiting the scope of discovery, the amount and types of evidence that can be submitted to ensure it doesn't take too long in the process of court proceedings. Participating in any methods of alternative dispute resolution. They can direct parties to attend any ADRs. However, this is just usually mediation. But they might determine to send them to arbitration or conciliation as well. They can restrict the time for final hearings, including limiting the number of witnesses that can be taken to court and the time to make submissions or even cross examine witnesses. And then we see a summary table of all the features and things you need to know about our ADRs. So mediation involves our mediator as the third party. They're unbiased, impartial, all of these parties are. They listen to both sides of disputes and act as a facilitator. So they just aid discussion and communication between the parties, but do not provide their own opinion. In conciliation, the third party is a conciliator, and they're actually an expert in the particular dispute issue. They listen to both sides and both parties and facilitate discussion between the parties and give some suggestions about how to resolve the dispute. Ultimately, neither mediation nor conciliation can impose any outcome. The parties have to come to it themselves, and it is not legally binding. However, if we attend these as part of the directions given by the judge, we parties may actually come back to court and sign what's called a deed of settlement, which would be a legally binding contract that will make the settlement that was agreed upon legally binding. But this can only be done in the courts, and is not always done. So we just have to trust the other party to basically uphold the outcome. Arbitration is where we have the arbitrator. They listen to both sides of dispute. It's much more formal, and then provide a legally binding decision based on the evidence presented by both parties. Great summary table for you. Many of the things I talked about, but it gives you some of the main points when you discuss appropriateness and inappropriateness. Super helpful table. Make sure to have a look. Now we'll look at civil remedies. So a remedy is the means by which a plaintiff's civil rights are protected or corrected for injury that's been caused to them by a defendant. The purpose of a civil remedy is to restore the injured party to the position that they were in prior to the harm occurring to them or being caused by the defendant. So we have two types. We have damages and injunctions, and they're split into their own types as well. Damages involve an amount of money being paid by the defendant as compensation to the plaintiff if they're found liable in the settlement of their claim, and this is the most common remedy that is imposed. Whereas injunctions are court orders against the losing party in a civil case, so whether that be the defendant or the plaintiff, but usually it's against the defendant. So the defendant has to do something or stop doing something to benefit the plaintiff if they've been found liable. And it either prohibits a particular act, which is a restrictive injunction, or it compels them or makes them perform something to benefit the plaintiff, which is a mandatory injunction. So the restrictive injunctions usually act to prevent further harm and correct the situation, whereas a mandatory injunction to actually go and do something usually serves to benefit the plaintiff in some way. But we know they're not so effective in correcting all the harm suffered by the plaintiff because the harm has already occurred, unfortunately. So the purpose of damages is to compensate the plaintiff, and this helps to achieve the overall purpose of remedy. So you need to know the specific purposes and the overall purpose of remedies as well for questions. The overall purpose is to return the plaintiff to the position that they were in prior to the defendant causing them any harm. And injunctions aim to rectify or make right a situation caused by the person who was found to be in the wrong, which is usually the defendant, where an injunction is involved, and they can again help achieve that overarching purpose of returning the plaintiff to their original position. So when we have damages, we have to ask a lot of questions. What kind of harm did the plaintiff suffer? And this may um, require different types of damages to be given. There may be unquantifiable losses that we cannot actually calculate. Um, it might be possible that damages could not return to the plaintiff fully to the position that they were in before the harm occurred, and it may be unable to compensate the plaintiff for all of their troubles. With the injunctions, we can ask questions like, has the defendant already done something damaging? And the plaintiff is stopping the defendant from causing any further damage. Will the injunction stop the defendant from doing other things that could harm the plaintiff? Would the defendant comply with the injunction? And even if they do comply with the injunction, does it mean that the plaintiff will be fully returned to their original position? So these are questions to prompt you when you have those questions that ask you whether a remedy awarded would be affected in achieving justice and restoring the plaintiff back to their original position. But you can definitely think outside of these questions. These are intended to help you go and revise, look at the specific types of damages and injunctions and their specific purposes, look at damages in particular. There is a lot, and you should have tables with strengths and weaknesses of each type. And how they do effectively restore a plaintiff and do not effectively restore a plaintiff. Again, these are quite common questions. All right, wonderful. That's all for Unit 3. Now we're going to jump into Unit 4, starting with the area of Study 1. Again, study design attached for your reference. Remembering you need to know a specific High Court case and be able to discuss it. And a specific referendum. Most people do the Aboriginal and Torres Strait Islander People's Referendum. I'm sure this will be the case for most of you. Most schools do this one. And those are your questions. So starting with the composition of parliament, which is crucial for you to know, we have the lower house, which is at Commonwealth Parliament level is called the House of Representatives. This is where government is formed by the party that holds the majority of seats in the lower house following an election. And state parliament, this is the Legislative Assembly. Now, the upper house consists of the Senate in Commonwealth Parliament and the Legislative Council in Victorian Parliament. The Queen's representative, the Crown, is at the very top, and the Crown doesn't actually do this work. There are special people allocated to basically represent the Crown. So this is the Governor General at Commonwealth Parliament, and in State Parliament, this is the Governor. Making sure you don't confuse the vocabulary. One of the most common reasons for students losing marks is because they can't tell the difference or remember the vocabulary of the houses and the Crown's representatives. You need to make sure you're all across this. Understanding the levels of parliament. Hopefully you guys don't struggle with it too bad in starting to understand it. It is possible after time and some study to get better at this area of study. Some students really like it, other students completely dislike it. But yeah, it is necessary content, and it's very common in Section B questions on Unit 4. So roles of the lower house is very common types of questions as well. Be prepared to apply to a stimulus as well. They form government. Again, that party with the majority of seats form government. They initiate debate and vote on bills. Most bills are initiated by the lower house because the government party often has the majority of seats here. So it's easy for them to pass bills through the lower house as party members will vote along party lines. And it's the Senate where it might get stuck. They control government spending, so they can initiate money bills, which the upper house cannot do that. They can act as a house of review for bills that were first introduced in the Senate, though this is more rare. They can scrutinize government, examine bills or issues in committees, so they can, for instance, have parliamentary committee investigations, and they form representative government because they are directly chosen by the people, so they represent the people's views and interests in lawmaking. Now, the upper houses basically have almost all the same roles. There are just a few differences. Instead of representing the people, forming representative government, the upper houses represent the interests of the states or regions of Victoria. They cannot initiate money bills as well. They more commonly act as a house of review than initiating bills. And they also scrutinize government and examine bills and issues in committees. Next are the roles of the Crown. So under the constitutional monarchy, the Crown is the head of state, and this applies to Australia. However, we have representatives to act on behalf of the Crown. So the governor doesn't have the same power as the crown, basically, but they just represent the crown. The roles of the crown are to grant royal assent, which is that last step after a piece of legislation, a proposed law, which is a bill, has passed both houses. The last step in order for it to become an act is royal assent. So the governor general, or the governor, depending if it's Commonwealth or state, respectively, must grant royal assent, basically give their approval and sign off on a bill for it to be passed, and then it will become laws or legislation. They may also withhold royal assent, which is extremely, extremely rare, but they can do this and refuse to approve a bill. Maybe if they suspect some kind of corruption or the bill is really bad, they would interfere. They also appoint an executive council, which is relating to that government party in the lower house. They appoint federal judges. So we can see an overlap between judicial powers here a little bit, but they're unbiased, and they can dissolve parliament. So they can actually just have a re-election early if they have suspicion to believe that there are problems within parliament or corruption within parliament. Um, Next, we'll talk about division and separation of powers. Both types of terminology you need to be very familiar with. The division of powers are lawmaking powers given to parliaments to create laws. So, state and commonwealth parliaments, which are our two types, have different powers, and this is what the division of lawmaking powers within the Constitution aims to address. So, these are exclusive, concurrent, and residual powers. Exclusive powers are the lawmaking powers that can only the Commonwealth Parliament can exercise. They're usually specifically stated within the Constitution, or by default, it is something that only the Commonwealth can do. And it wouldn't make sense for the states to be able to do, but usually stated in the Constitution. So some examples include defense, currency, border protection, military, and so on and so forth. Import and export out of the country. And these, yeah, only the Commonwealth can legislate. You need to be able to give examples of all of these as well. So make sure you remember some examples. Concurrent powers, just like it says, these sound exclusive. So only the Commonwealth can do it. It's exclusive to the Commonwealth. Concurrent, clashing. So both the states and Commonwealth parliaments have lawmaking powers here in these areas. Hence the term concurrent. So some examples include trade, taxation, and marriage and divorce. So if we look at taxation, for instance, what are some examples of Commonwealth tax? So everyone is taxed based on their income, how much money they make per year. That's a Commonwealth tax. That's countrywide. That's consistent across all of Australia. However, you have taxes based on your state as well. So you might pay a tax to your local council within the state where you live, and you have your house. That's a state law with regards to taxation, as an example. However, laws can contradict in these areas, and this is where Section 109 comes into play, whereby if a law of the Commonwealth and the state are clashing, the Commonwealth law will prevail, and the state law, to the extent of the inconsistency, so how much of it clashes with the Commonwealth law, will be declared invalid and be scrapped, but only to the extent of the inconsistency. So we see that there, and it is quite helpful to, especially Commonwealth shall prevail, state law to the extent of inconsistency being valid. You need to completely learn this. Remember basically word for word those couple of components that I mentioned, because students actually lose marks for not mentioning that the Commonwealth law will prevail and not mentioning that the state law only to the extent of the inconsistency is invalid, or not mentioning that this only applies when there's an inconsistency between state and Commonwealth law, and that this is with regards to concurrent powers. Wonderful. Yep. So Section 109, what does this mean? Kind of want to show that Section 109 often serves to increase and expand Commonwealth law at the cost of state law, and some prior cases that have happened serve to show this, which is where you might be talking about Tasmanian Dams case, where Commonwealth power was actually expanded, increased, as under external affairs, they did have power to legislate into a previously residual area, a state law area, which was with regards to the environment, because they had signed UNESCO World Heritage Treaty and they wanted to protect the Tasmanian Dam from having construction. And the Tasmanian law had to be scrapped to build a dam there. So that's flash revision of that case because we don't go through it today, but you need to remember that you have to know quite a lot of cases for this Unit 4. Make sure you're very aware of that and go and revise. And residual powers. These are law-making powers held only by the state parliaments, such as criminal law, education, and public transport. All by default makes sense that the state should have it. And it's basically any power that is not mentioned in the Commonwealth Constitution. It by default becomes a state parliament power. So only the state can legislate in these areas. So the majority of lawmaking powers should be with the states. Because the idea of the Constitution, when it was made, was not to take away power from the states, but allow them to keep it. You can imagine all the states had their separate thing going on, and then basically, let's make a Federation of Australia, let's all come together and become one country. The states wouldn't have been, happy about that because they had their own systems. So when the Constitution was being drafted, the idea would be that states would still have all of these powers and be able to do most things independently and have their own laws. Um, the Constitution acting as a check is another dot point of the study design that you need to know about. The 5 key ways, which you need to go back and revise: the bicameral structure of Commonwealth Parliament, the separation of powers, express protection of rights. You need to know all of the 5 express rights, the role of the High Court in interpreting the Constitution, being able to declare laws invalid or ultra vires, and the requirement for a double majority referendum, which is, as we know, difficult to achieve and thus protects the Constitution from being altered unless the people are in support of it. So these are very detailed points, so we're not covering them today, but this is definitely a reminder for you, helping to prompt you and think about these. But this is a kind of a big area in Unit 4, Area of Study 1 that you need to go and revise. Let's look at external affairs now. So under Section 51, subsection 29, Commonwealth Parliament has the power to create laws in relation to what is called external affairs. And you need to be able to define and explain this and apply this as well to specific examples. So it enables the Commonwealth Parliament to pass laws that reflect international agreements Australia is a signatory to. This includes treaties and declarations. It's been interpreted by the High Court that this applies to those treaties and declarations of an international nature. And this means that they can legislate into residual powers, into matters that are outside their lawmaking powers, and on treaty topics that do not exist in the Constitution. And they would also, by default, fall into residual powers, as long as this is to uphold an international agreement. International treaties in particular, they are legally binding under international law. If Australia does not uphold these, they can have penalties like barriers to import and export with certain countries because they're not upholding a treaty. So it is really important under external affairs that they can do this. It's kind of crucial for Australia politically. Declarations are not legally binding. It's usually they become treaties later on. It's when countries are just talking, we should do this, we should do that, and they may uphold those things that they talk about that they want to change or improve on, or they may not until it finally becomes a treaty and then different countries sign to it. So we do look at this in the Tasmanian Dams case and the Commonwealth v Tasmania because this is the case you need to be able to discuss and put into context of the external affairs powers. So Tasmanian government tried to dam the Franklin River in Tasmania. They passed an act, which is basically a law to do so. There was a lot of public outrage. The Commonwealth Parliament noticed this and decided to pass laws against it, even though it was a residual power, so a power of the states. So the Franklin River was placed on the UNESCO World Heritage List in 1982, which was an international treaty that Australia had signed to. This gave Commonwealth the opportunity to pass the act stating that the dam could not be constructed because it was on the World Heritage List and needed to be protected as per the treaty requirements. Tasmania actually took this to the High Court. They said that Commonwealth had no right to legislate because it was a residual power, and that the law should be declared unconstitutional or ultra vires. However, Commonwealth brought up external affairs power, that they had actual authority to legislate here. High Court agreed with them and decided that this came under external affairs power, and thus Commonwealth legislation would be held valid. So the impacts is what you need to be able to discuss. It gave Commonwealth more power in the area over the states, in particular, the environment is the area of legislation. So they have more power to legislate over the environment. The residual power of environment was reduced for the states, and Tasmania was unable to build their dam. So the states' powers to legislate were decreased at the expense of increasing the Commonwealth's legislative powers. So to help the Commonwealth to extend their power, giving them once again greater power with regard to lawmaking over the states, which you see in basically all the cases you study in legal studies. So nothing new. Seeing some repetition there, some patterns. So yeah, Section 5129, External Affairs, great at preventing ultra vires from happening. Wonderful. And we're moving ahead into Unit 4, Area of Study 2. And then we'll have some study tips towards the end, not too many, just a little bit. I already mentioned best ways to study for legal studies, and what I said is absolutely the case. Revision, a lot of revision, and a lot of application, and practice exam questions, and examiners' reports. Feedback, repeat, always time conditions. So note here, and some of the stuff we don't cover because it is school dependent as well. You need to know either one parliamentary committee or one royal commission, depending which one you studied, their roles and their ability to influence law reform based on a specific recent example of one of them, and at least one recommendation that they gave as part of the Royal Commission or Parliamentary Committee. And you need to know at least one recent example of VLRC recommending law reform as well. And recent means within the last four years. So make sure it's in date. From whenever the final report was finished, that's your date from which it must be less than 4 years. Key skills and the kinds of questions you need to be able to answer: lots of discuss, analyze, evaluate here. Not the easiest questions, but if you understand this area of study, you will not struggle too badly with it. It's not too bad. So we have the roles of the Houses of Parliament, the representative nature of Parliament, political pressures, and restrictions on the lawmaking powers of Parliament, acting as factors that affect Parliament in its lawmaking. So in terms of the roles of the Houses of Parliament, you need to take into account the effectiveness of the lower house based on its composition following an election. So if we have a majority government, it's nice and easy to pass laws for Parliament because there is a majority government, a party with the majority of seats, meaning they have more than 50% of votes yes for bills that they initiate, so they can quickly pass bills through. There could be some interest and a little bit of corruption as part of that because especially if the Senate is a rubber stamp. And then we have hung parliament, where it's basically a minority government. No party has the majority of seats. It might be difficult and time consuming to pass laws through, but it could at the same time make sure that laws that are being approved, bills that are being passed, are in support of a large array of members of parliament, demonstrating that they probably are beneficial and are very good. Now, the effectiveness of the upper house depends if it's a rubber stamp Senate or a hostile upper house. The rubber stamp Senate is rare. This is where the same party in the lower house that forms that majority government, that has the majority of seats and makes government, also has the majority of seats in the Senate, meaning all the bills get passed through quickly. This is great for Parliament in lawmaking. Majority government just initiates a bill. It goes to the majority. Majority of seats of the same party are also in the Senate, so they just vote yes too, and all the bills come to pass that the government wants during that period until the next election. What we usually have, though, is a hostile upper house, where the composition of the Senate is different to the composition of the House of Representatives, and the government does not have the majority of seats in the upper house, meaning that bills will adequately be debated and scrutinized to make sure that they are effective and approved by the community. However, it can also add delay to laws being passed. There might be requests for amendments, It may prevent bills from getting passed through, so it negatively affects Parliament in lawmaking. The representative nature of Parliament. So we know that we have representative government. They're directly chosen by the people as per the Constitution and reflect the views of the majority. So this should improve their lawmaking and make it representative of the community. We also have regular elections where people can vote out members of parliament if they think they're not doing a good job and they're not reflecting their views in lawmaking. Some limitations include popular laws, reluctancy, and difficulties in predicting the future, which may lead to laws that are not so effective and not so great. Parliament is going to be reluctant or hesitant to pass bills that they think is controversial and members of the public will not approve of. And they may hold this off and not do it during their election period, which is a few years, so quite significant. These laws may be needed. And they, for instance, might not be able to take future circumstances into account when drafting bills and not be able to predict the future. Now we have political pressures. So some domestic pressures, individuals, organizations, or businesses may place pressure on politicians or parties to implement law and support law reform that suits them. So think about individual means of influencing law reform, like petitions, demonstrations, and organizations or businesses may have significant power, power in the media, as well as wealth to place some pressure on politicians to change the laws that they create. Internal pressures mainly refers to members of parliament themselves being pressured to vote along party lines. However, we do see that this may be overcome. Some parties do. Sometimes people do cross the floor of parliament and they vote with the opposition and vote against their party if they're really against a certain change in the law. However, this will affect their status in parliament and in the eyes of the public if they do this. And then we see international pressures where countries, international organizations, or events such as COVID may affect and pressure parliament to pass certain laws. Then we see some restrictions on lawmaking powers of parliament, and this includes the division of powers, specific constitutional prohibitions, and challenging the law ultra vires. The fact that some of their laws can be declared invalid, but this is, as we know, difficult to pursue. There's no compensation if an individual is successful in proving that it was beyond Parliament's scope of powers. Needs time and costs. Need to be have standing and be personally affected. Division of powers. We know they cannot legislate into residual, but for instance, external affairs powers may help them to do that. And there are specific things that they are specifically prohibited by the Constitution, such as changing the words of the Constitution unless with a successful referendum they can only do so, and this must be Commonwealth Parliament. Now, the role of the courts, their main role, you might get asked this, is to hear cases and resolve disputes. It is not the making of common law. That is another role of them, but it's not the primary role. It's to hear cases and resolve disputes. So judge-made law is referred to as common law, and it is reactive, not proactive. It can only be made when a case that requires statutory interpretation or there is no already existing law to be applied. Only then statutory interpretation may occur and new common law can be created. So that requires a specific case coming to court with specific circumstances, no existing law being there, and or a need for statutory interpretation arises, such as if the law is unclear, vague, ambiguous, etc., etc. So this establishes legal principles known as precedent, and the doctrine of precedent is super important. Remember back to year 11 when you first studied this, you need to know this back to front, really. It's an important section of our common law system. It allows for consistency and clarity in how cases will be decided based upon how previous cases with similar facts were decided by previous judges. So it ensures consistency primarily. If a dispute comes before a court that is a little bit confusing, courts will first look to see if there were previous cases that already dealt with a similar dispute with similar facts and apply the precedent established in these. And we know if the court in which the precedent was initially established, that legal principle, the ratio decidendi will have to be followed by all of the lower courts within the court hierarchy, within the same court hierarchy, in order for that ratio decidendi and that precedent to be binding. It is only binding on lower courts in the hierarchy within the same jurisdiction. And if they cannot distinguish from the facts of that case and say, oh, there's different facts in this case, so I can make my own precedent here, which is absolutely the case. We can distinguish as well. It should, hopefully it doesn't confuse you. Once you look into it, it's a concept that makes a lot of sense. Wonderful. What are our reasons for statutory interpretation? We might see problems that occur during drafting. So sometimes we don't think about the future. Parliament cannot always predict the future. And they also may make mistakes. Not them, but they also have professionals drafting legislation on their direction. They will have a large team doing that. There might be mistakes. Future circumstances and changes may not be considered. It might not be clearly expressed what is meant by the legislation, might be inconsistent use of wording, and it may not cover new technology that may come out in the future. And these are all the reasons that you want to know: ambiguity, future circumstances, mistakes, technology, main reasons for statutory interpretation. And then there might be also problems that occur during application, which are more reasons for statutory interpretation. If the words are too broad, if it's outdated laws, words might be unclear or have contradictory meanings. Acts could have gaps, circumstances that were not considered and were never made part of the legislation. And because meaning of words can change. Wonderful. You need to be able to give examples of those. But more specifically, for these questions, you usually have a stimulus on the exam, and you need to apply what would be a reason as per the stimulus for a reason for statutory interpretation and relate it to the specific stimulus and link in, oh, okay, so how does this piece of legislation in my stimulus potentially not take future circumstances into account, and explain that in a specific way with your stimulus. So the effects of statutory interpretation: it might develop a new precedent, of course. It will develop new common law if statutory interpretation has occurred. Words or phrases in acts will be given meaning. And the scope of legislation could be restricted, reduced, or expanded. And that often depends if we interpret the statutes in a narrow manner, such as our conservative judges, or in a broad manner, such as our activist judges, that might expand legislation's operation. The factors that affect courts in lawmaking include the doctrine of precedent, judicial conservatism, activism, costs, and requirement for standing. So doctrine of precedent we just looked at. Conservative judges interpret legislation in a narrow way, as we know, judicial activists in a broad way, and they view the making of common law as one of their roles, whereas conservative judges try to leave it up to Parliament and avoid creating more common law legislation wherever possible. High costs deter people from pursuing and bringing claims to the court system, and time as well as the requirement for standing similarly does that as well. So strengths and weaknesses with the doctrine of precedent: it ensures consistency and fairness, that all cases are treated in the same way. By looking at past cases, litigants can also predict how their case is likely to be decided and thus make that considered decision whether to pursue their case for the courts or not. Courts can also develop law where Parliament has not yet created statute. There's no pre-existing statutory law. That's another reason for new common law to be created. And weaknesses: it can be inefficient because in order to change the law and keep it updated, litigants have to first bring a case before the court. Again, the courts are reactive, have to wait for a case to come before them, otherwise cannot do anything. However, it is also difficult to know when a judge might decide to distinguish a case. They could say that the facts are different and still be able to create new precedent in that case if they're able to distinguish from the case in which the precedent was initially established. Again, it's expensive and time consuming for litigants to initiate claims. So oftentimes it just doesn't come before the courts. We'll look at judicial conservatism and activism. Judicial conservatism is the idea that courts and judges should demonstrate caution when making decisions and rulings that could lead to significant law changes. It maintains stability, it leaves lawmaking to Parliament, and restricts the ability of courts to consider social or political factors or be proactive in changing the law. So it slows the development of common law. Um, by leaving lawmaking to Parliament, it is upholding its supremacy, and they should better know about the views and values of the people. However, we know Parliament more so tends to act what is in their best interest, which is getting re-elected rather than in the people's. So judicial conservatives, uh, you know, it's not great because judges don't have any political bias. So we would like more judges to be activists and work on common law and advocate for common law. Now, activists are the opposite. They consider a variety of social and political factors when interpreting acts, conducting statutory interpretation, and deciding cases. They interpret the law in a broad way and want to develop common law further. It allows judges to recognize rights of people and community views in making more fair judgments and developing common law in a beneficial and progressive way. But it could lead to more appeals and lead to radical changes in laws that do not sit well with the community and are questionable or cause issues. At the end of the day, they're not experts. They don't really know or even have the capacity or means to investigate what community opinion is as to laws needing to change. So it's not always appropriate. We also have costs of bringing a case to court. So we know that taking a case to court can be very expensive. Some individuals may not be able to afford this or even qualify for legal aid because courts can only make laws on cases that come before them. This can be a problem. So, however, the costs help to discourage frivolous, unbiased, and crazy claims, and they can encourage parties to use alternative methods or other institutions and further reduce backlog and have those easy, more simple claims have resolved elsewhere rather than taking up court resources and time. Weaknesses include that litigants who cannot afford costs, who may actually need to pursue claims and may give an opportunity for statutory interpretation, they may not actually have the opportunity to pursue their case in court. And it can deter parties from pursuing appeals as well, which would be an opportunity to develop further precedent as well through appeals. Requirement for standing. The idea that the litigant has to be directly affected by issues involved in the case in order to be able to pursue the case through the courts. Make sure again that people only who are genuinely affected by an issue can bring the case claim to court. Encourages people not directly affected, such as activists, to seek other avenues, such as petitioning, to try to influence a change in the law, and they can do so more so through parliament, such as petitioning. Some weaknesses. People who have a general interest in a case and advocating for the law have no right to pursue a legal challenge on behalf of public interest or the common good. Unfortunately, even though this could be beneficial, potential benefits just listening to community opinion and those with intellectual interest in the case are lost due to the requirement for standing as well. Looking at the relationship between courts and parliament now, these are all the factors you have to be able to discuss. So the supremacy of parliament. Important to understand that parliament is the supreme lawmaking body. They can change laws as long as it's in their constitutional power. So they can also override court decisions as part of that. So they basically have more power than the courts with statutory law. And they can even pass legislation to change the jurisdiction of the courts as long as they keep them separate and independent as per the constitution. At the same time, we know that the supremacy of parliament is limited, where they cannot change words in the constitution without referendums being successful, which is unlikely. And we know that courts can declare ultra vires or beyond the scope of parliament's powers, laws that go outside their constitutional jurisdiction. Courts influencing parliament as well. Judges can directly influence parliament by making comments when they hand down judgments called our obiter dicta comments. And they can just say, I don't think this law is appropriate. I think it needs to be changed. Parliament may or may not respond to that. So this is obiter dictum. In Latin, that means said in passing by the way. So by the way comments, their opinions or statements that do not affect the outcome or judgment of the case, because as a judge, we have to follow statutory law if there is applicable statutory law, but they can still make comments and these may affect Parliament's lawmaking. Looking at statutory interpretation, courts are responsible for applying the law, therefore, applying statutes is important. Courts have the ability to interpret statutes, parliament made law, and they can clarify words or phrases within legislation, expanding or restricting legislation's operation, which is really important and contributes to the law developing further. So that relationship between statutory and common law is established through statutory interpretation. So codification of common law, because Parliament is the supreme lawmaking body, they have in this area, with both of these points, more power of the courts. They can decide to pass legislation that confirms and agrees with a precedent set by a court and makes it actual statutory interpretation, makes it a part of Parliament-made law. So they can demonstrate support for judge-made law principles, for common law principles, but they can also abrogate or remove common law, unfortunately. They can pass legislation that overrides or abrogates a precedent set by a court, except for high court decisions based on constitutional issues. So there is an accompanying exception. And they can do this because they maybe believe that courts interpreted statutes incorrectly or they did not reflect societal views accurately, such as maybe our judicial activists. Maybe they made those radical changes to the law, for instance. Reasons for law reform that you need to know, and you need to apply these to stimulus materials usually and state, oh, one reason, in this case, that the law experienced a reform is X, changes in societal values and attitudes, and then you need to link it in specifically and explain it specifically to the stimulus. So don't expect to do these without a stimulus if you get them. And there they are on the slide. I feel like they're all quite self-explanatory. If you have any questions, utilize the chat, but they're very straightforward. The means by which individuals can influence law reform include petitions, demonstrations, and court cases. So petitions are our formal written request to Parliament for action to change a particular law that is, according to the public, in need of reform. That can be electronic, e-petitions, or paper form. So the strengths of petitions are that they're really simple, easy, and inexpensive, or even free, for people to demonstrate their desire for law reform. And we can collect a bunch of signatures to show widespread community support for law reform and get a lot of attention about a petition and an area for the law to be changed. Once a petition has been given to a member of parliament, they have to present the petition in parliament and discuss it. They may brush it away and decide not to do anything about it, but it has to be tabled, so meaning discussed in parliament, giving it an opportunity to make an impact. Some weaknesses, however, parliament receives hundreds, if not thousands, of petitions, and they also have no obligation to implement the law reform, so they can just brush it off. And influence of the success of the petition may depend upon who tables it in parliament, who presents it in parliament, what party member, also depending upon how much signatures it has and the contents of the petition itself. Is it controversial or is it not controversial? Because we know parliament doesn't like to they're reluctant to make controversial laws. Now, demonstrations, people actually gather to express dissatisfaction with existing law and demand some change. Popular demonstrations often get into the media quite well and have a wide outreach, both to parliament and other members of the public. It can also raise social awareness as part of that as well, of an area for law reform and get even more support. However, they're not taken seriously. If they turn violent, then individuals are perceived as very radical, and it becomes controversial for Parliament to even change the law when that's being represented and advocated for by a group of violent people. It can be hard to also plan or organize them, and they can even be impacted by factors such as weather, making them difficult to do. And lastly, of course, we have court cases. People are able to take cases to court and challenge legislation, say it's unconstitutional or unfair. So it can enable unclear legislation to be clarified through statutory interpretation if there's an opportunity for that to arise and develop further common law. Judges are also politically independent and will make rulings on legal principles and the law alone rather than political pressure, which they are not influenced by, so it may be more fair. Weaknesses, however, individuals need standing and could also be deferred by times and costs, and judges will only be able to change common law if a case comes before them and there's no pre-existing precedent that is binding and that they have to follow, and they can only change common law in relation to the specific issues in the case brought before them. Then lastly, we have media. You need to distinguish between traditional and social media and their roles. So traditional media is things like the newspapers, television, and radio. They mainly inform about legal issues in a more unbiased way, just giving news and information, um, and examine potential legal issues and law changes. Whereas social media is more focused around communicating lots of information to a wide variety of people and giving opinions, which can also be more biased. But it also has the opportunity to connect people, have a wide outreach, and even communicate to members of parliament and government. So this includes our social media and internet tools and platforms. Might need these questions to be applied to a stimulus as well. Lastly, our VLRC, independent government funded organization, but investigations and terms of reference are given to them by the government. They monitor and coordinate law reform activity in Victoria and advise ways that laws should be changed, reformed, and updated. They can investigate issues comprehensively because they have all this government funding and resources, have direct connection to Parliament through the Attorney General, which gives them terms of reference to conduct specific investigations, meaning they have more of an influence and are likely to be taken seriously. Still, Parliament has no obligation to follow any recommendations, and VLRC, however, are government funded, though they say they are independent, so there could be underlying government agenda present. Just as a speculation as well, let's not be definitive there. Parliament responding to law reform, again, we need to understand that they can do this quite well as they're elected and the supreme lawmaking body. They can investigate the need for law reform and they can respond pretty quickly. With the courts, judges can make decisions without political pressures. They can declare legislation ultra vires, and courts can also highlight problems and raise awareness. So this goes back from a lot of the content that was already discussed and studied throughout the year, but this is the last point of the study design, and you need to be able to evaluate questions here, so strengths and weaknesses. Lastly, with some final tips, making sure that you pay attention to task words, content words, limited words, and mark and time allocation when you're answering questions. Time yourself. Make sure you give yourself a minute and a half per mark because that is based on exam timing every time you do any practice questions. Task words direct you how you will have to structure your responses and what specific components will need to be included as part of your response. Content words direct you to where from the study design your content needs to focus on. And limiting words tell you what not to write. So if it says, for instance, one example, if I start writing a second example, I will not be marked past the point where my first example ended. So don't be that student that, oh, I don't really know this very well, so I'll give one sentence for one of my examples and I'll give two sentences after that for my second example. They won't mark you past the first example. So just be very careful. We see an example of them being highlighted. Discuss is my task word, to is my limiting word, responsibilities of legal personnel is the content words that I'm being directed to, and mark allocation of 4 marks means I have 6 minutes for the question. This is just to help you guys on this slide. This is the what you have to do for each type of question. You should know this at this point, but if you want to review, make sure to read through this again. Your most common types of questions that students also get confused on. And some time limits breakdown. So your 10 marker on the exam should really only take you about 15 minutes. So make sure you use reading time as well during the exam to start planning for it. Now, in terms of your study process, once you have knowledge and understanding, so once you have done really sufficient, adequate revision of Unit 3 and Unit 4, then go and apply your knowledge to practice questions and fill in any leftover remaining gaps. There's no point really in doing practice questions if you're doing them open book or if you don't have the revision done already. You will not get much out of it, and application is crucial. So this is the point of the year where you really need to be doing that revision and doing practice exams for legal studies. It's going to be fine. Everyone's going to do well. Make sure you put in the time and effort. It's definitely possible for everyone to do well in legal studies if you put in the work and do what I recommend. That is how I studied, and I did not spend even that much time studying because I did it effectively. So I encourage that for everyone. There are some techniques you may follow that might help you and make legal studies more fun and doable for everyone, because there is a lot of content as well. Try flashcards, try making summaries of bits and pieces of areas of study, maybe even using this PowerPoint. And a lot of the content here covers a lot of things you've learned over the year. Go through the study design, discuss concepts with friends, and learn them better and consolidate them better that way. And again, timed questions most important. Use your teachers, get more feedback from them. Don't just always self mark yourself. Don't be afraid to consult with your teacher and ask a lot of questions. So be like Bill, at least one legal 10 marker a week, especially this time of year, maybe more if you don't do too well on them, do a lot of them. They help improve your responses to other questions as well because they're quite long and complex. Well done, guys. That's all of legal studies units 3 and 4. All of the content for the year done. Really wanted to say best of luck with your upcoming exam. Don't give up, stay motivated, have fun with the subject. I really hope you found this lecture helpful. And really best of luck for your upcoming exams for all of your subjects.